The Obamacare ruling, it is a blight on the United States Supreme Court, and I think it has damaged not only the court, but Chief Justice John Roberts. I'm Mat Staver, founder and chairman of Liberty Counsel. Joining me is Steve Crampton, who is the vice president of legal affairs and general counsel of Liberty Counsel. And Steve, I've not been more disappointed in a decision from the United States Supreme Court in recent times than I was with regards to this Obamacare ruling.
Matt, I think, the historic nature of the ruling, the lead up to it, the fact that we had what even today most commentators would say is a liberal or a conservative majority on the court, and to have a ruling that sort of butchers the Constitution at its fundamental level, the very structural provisions of the Constitutional and enumerated powers, is an incredible blow, I think, to the nation at large, isn't it?
It really is, and to see that John Roberts is the one who ultimately made the 5 majority on the taxing and spending clause. It was stunning when I was watching to see the ruling, and there was some media that got it wrong, and for good reason, because the issue was whether Congress had the authority under the Commerce Clause. That was the primary argument before the court over these 3 days, 6 hours of arguments. And when they came out and they started with that,
right,
and then they said Congress doesn't have the authority, and then they went over to the Taxing and Spending Clause and says, well, maybe Congress have the authority under the Taxing and Spending Clause, even though it's not called a tax.
Yes.
We're going to construe it as a tax.
And there was that other provision, the Anti-Injunction Act, that was argued as well, under which if it is a tax, we can't sue. And the court began also by pointing out, and the government argued, it's not a tax under the Anti-Injunction Act. So you have in the same breath, it is a tax and it isn't a tax.
Yeah, you can't have both conclusions. You can't say that it's a tax, but the Anti-Injunction Act doesn't apply, because it applies if it's a tax. And the way it applies is you have to pay the tax,
right,
and then ask for a refund. You don't like the refund, then you file suit.
Right.
Which, when you apply that to Obamacare, that would be 2014. When it goes into effect, the tax would be assessed in 2015. So the earliest that we could get into court is 2015, meaning that now, if it's a tax, the court doesn't have jurisdiction to enter the ruling.
Exactly. No jurisdiction. That's right. And yet here we are with it, as I say, in preposterous fashion. Chief Justice Roberts, who desperately wants to claim the mantle of judicial restraint, has created a tax and has contradicted himself and made the act internally inconsistent.
And then if it's a tax, and I don't want to go into this too much because it's more deep weeds, but if it's a tax, it has to be uniform. And there's a constitutional provision that says you cannot have a direct tax or what's called a capitation tax.
Right.
And the court does very little to address that in its majority opinion.
Yes.
And that's a huge issue
it really
because
is.
it is not uniformly given across the country and across individuals.
And one other tax point before we move on is tax bills, of course, must originate in the House. This bill did not originate in the House. So, it is a total mess, in spite of the fact that we have 9 very bright individuals who are steeped in constitutional theory and history addressing this thing.
It's amazing how much damage this has done to the United States Supreme Court and to Chief Justice John Roberts. I think
so too.
He did a terrible job in the situation. And at a minimum, he should have had this thing re-argued and rebriefed on the tax issue, because that was not a focus of this case. But clearly, even to go off on that is just it's as much hocus pocus as Roe versus Wade is.
It really is. And the other thing that's extraordinary, as you say, with regard to the reputation of Chief Justice Roberts, what most folks that haven't looked at the opinion don't understand is you have the opinion of Chief Justice Roberts that basically controls here, and yet not a single other justice joined him in that opinion, in the bulk of it at least. So you have a separate opinion by Justice Ginsburg, joined by most of the liberal justices, who really attack Chief Justice Roberts' opinion from the left. And then you have the joint dissent itself, highly unusual, with the rest of the real conservatives who also take issue with Chief Justice Roberts. So you have the Chief Justice who himself prides himself on being the uniter, not the divider, left out by himself, a man without a friend on the court.
He has no friends on the court in this particular decision. The other interesting thing, and I want to go back and follow up on what you just said about the Chief Justice and the decisions and the unusual so-called quote-unquote dissent, is that, the statute itself does not call this a tax.
Right.
President Obama said it was not a tax. Now, I know for political reasons, Republicans are now saying this is bad for Obama because now it's a tax and he's actually raised taxes. But in reality, the reality of this is the tax was created by the court itself.
Yes.
Because the statute does not impose this as a tax.
That's right.
It was not passed as a tax. It was not debated as a tax. The history of this statute shows that originally was a tax. They pulled that out and they changed it to a penalty because they knew they could not get that politically through the process if they pushed this as a tax.
Right.
So they literally moved it into a non-tax. It is the court that has no power to tax that created this now and invented this tax in order to save the statute.
And argues all the while that, well, we can't really set policy, our job's very limited, we're just here to review, and blah, blah, blah. But again, pretending to be the model of judicial restraint. And it's not that by any stretch, is it?
And what I think happened is when you look at this dissent that's so-called written by Scalia, in my view, there's only a small part of it that's written by Scalia. And when you go to that dissent, you'll see like 5 or 6 asterisks that separate the main dissent from what I think Scalia did. And that's only about 2.5, maybe 3 pages. And that part of it is classic Scalia, where he takes on this ruling of the court. And he does it in a Scalia classic acerbic way. The rest of the so-called dissent is written like a majority opinion. We find. Well, the dissent never finds. It's the majority that find. They talk about the government's position, and then they attack the government's position. It is written like a majority opinion.
And to buttress that point, Matt, is the fact that when they refer to Justice Ginsburg's joint kind of concurrence and dissent, they never refer to it as anything other than a dissent, as if to say they're in the majority, Justice Ginsburg is in the minority. In fact, as it turned out, because Justice Roberts, the best information suggests, switched his vote after the argument.
Yeah, I think he did switch his vote after the argument. I think during the week of the argument, he voted 5-4 to strike it down under the Commerce Clause and under the Taxing and Spending Clause. The opinion was written, and especially if you're doing this for judicial restraint, if you're going to uphold it under the Taxing and Spending, you don't even address the Commerce Clause. What the court do? It addressed the Commerce Clause first.
At great length.
At great length, said that Congress doesn't have the authority, and then it went off on the taxing and spending. Sometime after the writing of the opinion was going on, Roberts jumped ship on the taxing and spending, and thus you have this bizarre opinion.
And I believe this kind of points up, it's an incredible study, I think, in our entire American structure of law, because the whole idea of the Supreme Court intended to be objective, neutral, removed from the political fray. I think what you have here is because the world was watching this opinion, everyone knew that this was a fundamental shift in the way we approach government. Frankly, a great leap towards socialism. That Justice Roberts himself read those opinions and was influenced, as often happens, unfortunately, by the political sway rather than the legal arguments. And so you have a terrible outcome as a result.
It is a terrible outcome. Well, we want to talk, not in this program, but in another program with regards to the impact of Obamacare and what's the prospect of overturning this politically, or with what the states are doing with regards to them saying, we're not going to participate in this exchange program, and we're not going to expand our Medicaid funding programs either. What does that have as an impact on this, and what will it have as an impact on the upcoming political elections? I'm Mat Staver. Steve Crampton is here with us talking about Obamacare. It is, in my view, one of the worst decisions in history in the sense that it just simply invented the law, created a brand new statute, and then ruled on it, imposed a tax, And ironically, 20 years, almost to the day, after something similar happened in the Planned Parenthood versus Casey decision, where Kennedy shifted his vote during the writing phase as well. What's the commonality? Well, one commonality is both of them fund abortion. They're the largest funding of abortion in history under Obamacare. Go to Liberty Counsel's website, lc.org. We're not done with Obamacare by any stretch of the imagination, either legally or in the public arena. Go to Liberty Counsel's website, lc.org, and join us as we continue to defeat and combat Obamacare.